Now, if you remember stages of crime, there were 4 stages. Do you remember the stages?
Yes, ma'am. Little bit like
Yeah.
object, intention, object, preparation, execution, or something like that.
Intention, preparation, attempt, and then commission.
Object. Okay.
Yeah, object is not there. So intention is there. You have the intention, then you prepare for it, then you attempt to do it. So your attempt might be successful or unsuccessful. It is, if it is successful, means commission of the offense is there. So there we saw that when we talk about attempt, for certain offenses, for attempt, a specific section is there. Okay, so like there are certain offenses wherein we see that commission of the offense and attempt to commit the offense, whether you are successful or unsuccessful, same punishment would be applicable, because these are considered to be more serious or severe offenses. And that's the reason why, whether the person succeeds in committing the crime or he fails in committing the crime, same punishment would be given to the person. Like section 100 and section 121, like these offenses against the state, waging war and all, in those situations. Okay, then we have section 460. These are, because these are considered as liquoring house trespass, these are considered as severe offenses. So whether the person succeeds or not, same punishment would be given. As a result, there is only one section which provides for punishment for both attempt also and completed offense also. So this is how some crimes are like discussed. At the same time, there are certain crimes wherein attempt to commit offense and commission of the offense both have separate punishments. As in, offense is also covered, punishment is also covered. Like attempt to commit murder and murder, both are covered under IPC. At the same time, there are certain offenses, like you would say attempt to commit suicide. Definitely suicide is not a crime because the person already died. He is no more there to be punished. So attempt to suicide is a crime which is mentioned under 309. Like that, we see that for attempt, some specific sections are there. But then IPC is having so many different types of crimes that it's not possible that for every single thing they will provide one section for attempt and then another section for the punishment. Okay, and that is the reason why we see that for many other crimes, as such, we do not have a specific section for attempt. But what happens is, for whichever crime attempt is not separately covered under IPC, it will fall under section 511, which is the last section under IPC. Okay, so section 511 is the last section under IPC, which provides for punishment for attempt to commit some offenses. So there are some offenses wherein no specific provision are made regarding an attempt. So 511 will be applicable. It deals with those types of cases which provided that accused shall be punished with 1/2 of the longest term of imprisonment. Whatever is the maximum term of imprisonment mentioned, half of that would be given as a punishment, okay, to this particular person. So this is what 511 is all about, that whatever is not covered, everything will be covered under 511. So stages in commission of the offense and essential elements. An attempt is defined, and what is an attempt? It was defined in this case, Aman Kumar versus State of Haryana, that it includes the following. Attempt consists in the intention to commit the crime. The person was having all the intention. He made the preparation also. He attempted it also. But what happened is the person failed to achieve that intention. With that intention only he committed it. But finally the person could not succeed because of some reasons. In such cases, we will say that this is nothing but attempt. From his own part, he tried to do it only. But because of some situation, the person could not succeed. Okay, so as such, the word attempt is not being defined, but it just mentions that punishments are specifically provided under this section. Okay, so if a person opens a box in order to steal something from there, and later on he finds that there is nothing inside the box, this would be attempt. The person attempted to commit the offense of theft, but he could not find anything. That's why he failed in commission of the crime, right? So because for theft as such, we do not have a provision for attempt, this certain provision is going to be applicable, section 511. Why attempt is punishable under IPC? An attempt to commit a crime is a crime itself, right? The person from his side, he gave his best, but because of the situation or because of some other reason, he could not succeed. So every attempt falls short of success must create a threat in mind of the people, right? If somebody sees that his house was he went somewhere and the door was open, somebody broke his lock and things like that, but there was nothing inside his house, no valuables were there, so the person left. It's going to create a threat anyways in mind of the person. Even though nothing was stolen, he would be still afraid that okay, this sort of situation also might happen, maybe I should be very careful next time when I'm leaving the house. So it's going to create an alert or threat in the mind of people, which by itself is an injury and moral guilt of the offender. It is an injury to the person that he is afraid, he will think about it. So that is nothing but is incorrect. It is an offense in itself, even though the person did not succeed. And that is the reason why this provision is added. Okay, so if you look at the section 511. So what it says, whoever attempts to commit an offense punishable under this code with imprisonment for life or imprisonment to cause offense committed and in such attempt towards commission of the offense shall, where no express provision is made. Okay, some express provision is not there. In such cases, what will happen is for made by the for its punishment be punished with imprisonment for any description provided for the offense for a term which it may extend to 1/2 of the imprisonment for life, or as the case may be 1/2 of the longest period. If 7 years is the maximum punishment provided, 1/2 of 7 years, that could be the maximum amount of punishment which can be given, or such fine as may be provided for the offense, or with both. So this would be applicable in case of section 511. Okay, when we say imprisonment for life, what do you think would be 1/2 of imprisonment for life?
7 years.
Actually, after 14 years, the person can apply that he should be released and all, but for the purpose of section 511, right? Life imprisonment is considered as 20 years. So when we say 1/2 of it, it would be 10 years for the purpose of this section only. But otherwise, you are right, because 14 years, after 14 years, the person can apply for his early release and all. Before 14 years, it would not happen. But for section 511, it is considered as 20 years, just for the purpose of calculation. Okay, is it clear? 511.
Yes, ma'am.
In the document, I have added some explanation. Okay, you can refer that. Okay, so there are certain offenses relating to documents also, which are provided under sections 463 to 477A. And when we talk about offenses relating to documents, we have forgery and we have making a false document. Okay, so offenses relating to document we have. Now, what constitutes forgery? The very basis of the offense is making of false documents. Now, just making of false documents in itself might not be a crime. Okay, like take for example, you might have seen when we were in school, we used to get this free fake currency notes with some things that, you know, like some edible,
Yes.
right? 20
Yes.
rupees, 50 rupees fake currency notes. So as such, that would not come under forgery, because why that is created just to, you know, like give it as a gift to kids who would be very happy collecting those currency notes. So as such, that would not constitute forgery. But what will constitute forgery? Making of false documents is there with criminal intention to cause damage to any person. Same ways, when we talk about forgery, you will see the people who, like artists, right? Somebody who is going to the art school, especially when they start to learn oil painting, you will see what they will do is they will try to copy these famous paintings of famous painters. They will try to copy it, exact same copy they will try to make. Most of the oil paintings, they will start with that basic thing only. Now here also what they are doing, they are copying an original piece of art from big art books would be there, from there they would simply copy it. That is also not forgery, because why? They are trying to learn that art, but they are not having the intention of selling it to somebody saying that this is an original piece from so and so artist. So there also it would not be forgery. Same ways, like books, right? When you buy books, maybe for Indian Penal Code, you have bought a book, okay? And what you are doing is maybe you are taking Xerox copy of that. Why are you taking it? So that you can mark it and you can, you know, like write here and there, and you can make it all dirty, because you don't want to, you want to keep your book safe. That's why what you did is you made a Xerox copy of the entire book and you just made it all dirty and everything so that you can study properly. That's also not forgery, because you do not have an intention of selling that book to somebody and earning profit. You just did it for the purpose of your exam. So all these things would not be considered as forgery, because this criminal intention is not there to cause damage to any person. But if you buy a book and you start taking printouts, like Xerox copy of that book, and you start selling it to your classmates, that would be considered as forgery, because by doing that, you are causing damage to the original author. Nobody is going to buy that person's book. Rather, people would prefer buying the Xerox copies from you, because that would be much cheaper. In fact, there was a case like this, which we read in IPR, intellectual property rights. We read that case. Some Delhi University, uh, what they were doing is, the teachers of Delhi University, right? They were, you know, like preparing materials from Oxford University, Harvard University. From there, whatever books are published, from there they were taking this page from Oxford University book, that page from this book. Like that, they prepared study material for the students, and they used to give those study materials. And in backside of Delhi University, there was a Xerox shop wherein all the students would go. From there, they would collect the Xerox materials which teachers have provided. As a result, nobody was buying the original books from Oxford University, Harvard, whatever, but they were actually reading from those books only. So that those press, they filed a case against this Delhi University and the Xerox shop, claiming for it. So why that can be done? Because it is nothing but forgery. It is causing loss to the original publisher. Okay, so because it's done like for commercial activities, it is being done, that would be considered as forgery. Okay, so forgery implies false document, signature, or other imitation. If I put somebody else's signature in order to withdraw money, maybe on a check, I am putting somebody else's false signature or some other things, right? In order to gain profit, there also it would be considered as forgery. Maybe in some contracts I'm putting a person's signature to make the person liable. Those also would be forgery. If I'm creating fake identification of another person, like creating fake account and stuff, that would also be forgery. It would be included. So there are certain basic elements of forgery that it requires deception. Okay, so when we talk about forgery, like I mentioned, that just replicating an art piece is not forgery. But if I do that and if I try to sell it to another person saying it's an original piece of art from so and so person, buy it for these many lakhs, that is going to be forgery, because I have the intention of deception, right? I'm fooling the other person saying it's an original piece of art. Creation of fake document. Forgery also includes the creation of fraudulent or fake documents. Like it can involve photocopying of another person's signature and placing it on a document without the person's knowledge. Okay, so that would also be included. Then when we talk about literature, like I mentioned that Delhi University case, at a large scale photocopies were being done. So it was nothing but forgery again, violation of copyright. Forgery as identity theft. Identity theft is also a crime wherein defendant unjustly acquires and uses another person's personal data in some way that involves fraud or deception. A person might open a website and say that I'm so and so person, I'm providing this service. But actually the person is not that person. He is creating a fake identity so that people take the service from him. Those also would be included. Okay, when we talk about identity theft, I heard this many times. One, these some random websites would be there. What they do is they will, like I heard this one person saying the person had lost weight, okay, from so and so kgs. The person became so and so kgs without going to that particular, like fitness center. The person did all of that herself, and the person was on YouTube. So what that particular fitness institution they did is they took her photo and they placed it on their website saying that she came to our institute and she followed our diet and everything, and she has lost these many kgs of weight. That is also nothing but identity, because these people are trying to use her identity and like trying to gain customers. That's also nothing but identity theft, because it is done without the person's consent. The intention of the forger, whoever is doing the forgery, that person's intention is very much important. So section 468 pertains only to the cases wherein forgery is for the purpose of cheating. Forgery has been explained before as concerning presence of one or the other of these two elements. That is, accused dishonest intention is there and the person wants to commit fraud. So when we talk about forgery, the prosecution has to prove that accused committed forgery and he did that with the intention that the document forged shall be used for the purpose of cheating. Like I mentioned, replicating an art piece would not be forgery if intention to cheat or deceive another person is not there. So that intention has to be there, along with that forgery must be committed. And punishment for forgery is up to 2 years of imprisonment or with fine or with both. And it is a non-cognizable offense. Court's permission would be needed to arrest a person. It's again bailable and triable by magistrate of first class, and it is again a non-compoundable offense. Once the case is filed, court is going to decide on it. Parties cannot mutually settle the matter. Okay, is it clear?
Yes, ma'am.